Go ahead, if you would, please.
All right, I'll let you know when the case is being recorded.
Anything we need to know before we start, counsel? Okay.
The case is being recorded. Hear ye,
And I'm
hear,
not-
hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good afternoon, everyone, and thank you for coming. This is docket 2020-J-543, Commonwealth versus Jenell. Is it Thames or Thames, counsel?
I believe it's Thames, Your Honor. She goes by Thames.
Thames, okay. And I'm going to ask you each to identify yourself for the record, please.
Good afternoon, Your Honor. My name is Brendan Cox, and I represent the petitioner, Jenell Thames.
Good afternoon, Your Honor. Catherine Semmel, ADA for the Commonwealth.
All right, good afternoon, and thank you both. We're going to set the clock and keep track, but I'm interested to hear what each of you has to say. So I have some questions, but I'll give you a chance to begin first. Mr. Cox, I think it's your petition. I believe you're first. Is that right?
I believe so, Your Honor. Your Honor, the basis of the petition essentially is that Ms. Thames is held on the Commonwealth's motion for pretrial detention pursuant to Chapter 276, Section 58A, and the petitioner's position is that it's both an abuse of discretion and contrary to the law, a misapplication of the law to hold her given the circumstances in this particular circumstance. And I recognize that the court, each reviewing judge is entitled to significant deference when it's a matter of discretion. I recognize that. However, in this particular circumstance, there's some issues, I think, that some legal issues that combined with the discretionary decision result in a circumstance where Ms. Thames should not be, as a matter of law, should in this particular situation shouldn't be held, because the Commonwealth cannot meet its burden clearly and convincingly that there are no conditions that will reasonably assure the safety of any person in the community. And part of those issues include both the Commonwealth and I believe the lower court decisions rely extensively and heavily on Ms. Thames's board of probation record, her court activity record information, which there's no question, it's relatively speaking, it's a long record. The copy that I have, the most recent copy that I have, and the copy that I submitted is 17 pages long. And that's, I think, colloquially, sort of anecdotally, would be considered long in most circumstances. However, almost none of the offenses on Ms. Thames's record are the enumerated offenses under Section 58A that lead to or support a dangerousness finding. There are two older ones, and I recognize that the basis of the motion, the Commonwealth's motion here, relies on, I believe, two on the new docket in Lynn. So I'll sort of address those separately. The older docket entries on Ms. Thames's record resulted, one was an assault and battery dangerous weapon that I believe was dismissed, and the second one I think was
can I just tell you, as I see the record, I've got a 2011 assault dangerous weapon conviction with a knife. And there's a 9 months committed eventually on a probation violation from 2011. And then an assault and battery dangerous weapon that was dismissed 3607, the same day she took a suspended sentence for fraud in the same court. That's how I read it.
Okay. And that's the one that I meant to reference if I misspoke. I apologize.
I didn't think you were misrepresenting. I figured.
But the record is what it is. Here, though, the offenses, I believe, that the Commonwealth's motion, on which the Commonwealth's motion is based, the offenses on the Lynn docket 2013 CR 2539, there are 4 allegations. 2 of them are, I think, clearly are not subject.
It's all of a piece, right? It's a home invasion.
Right.
You put somebody in fear. There's gonna be a question of injury that I'm gonna ask Ms. Semmel about. I understand there seems to be an allegation, but I agree with you, that's not in police report or even in the Commonwealth's representation. But it's all of a piece, and it looks like an escalation, doesn't it, from her prior record? But you got a whole lot of B&Es, which frankly, I understand they're they're concerning. They change the way people feel in their homes. But not in the ones from 2012, and there's a bunch of them. And I understand they're all on there twice because I know how to read an old record. Because of the, no process in the district court. But this is the first one where it doesn't even appear she accidentally found somebody in the house, right? She seems to have gone in when the woman was unloading her groceries, right?
Taking the police report as written, correct. And the reason I hedge there is because Ms. Thames has a very different assertion
Okay,
about
fair enough. Okay, fair enough. So in your view, it's triable, because this is my second question, is I got it on for trial on 2/4, is that right? That's 2 days from now?
docket, I think, has been updated to reflect that the case is no longer scheduled for trial on Thursday.
Okay. And is it you don't have to answer this. You may be still consulting with your client. Is it going to be a bench trial?
Based on the most recent, so that sometimes is a fluid conversation, but based on the most recent conversation, it's not going to be a bench trial.
Okay. She's at Suffolk, right? At the Suffolk County House of Correction?
Yes, Your Honor.
I'm looking at, they're doing some vaccinations there. Has she been vaccinated?
She has received the first shot, and she has a vaccination card, so that if by chance the court were to release her on any conditions, she would have the card, which would enable her to secure the second shot when
Okay.
the time arrives.
Okay. Is the bed still open at Lowell House?
I have confirmed that as of this morning. I spoke with the
Sorry,
Lowell
I've
House
got
before.
asthma. I'm sorry. That's hence the cough drop and the cough in your face. I'm sorry. Well,
I confirmed that as of this morning, I have a written letter that confirms there's a bed available as of Monday next week. However, I followed up after I got that letter, and I have written correspondence from an intake counselor who says that if the earliest she could have a bed is Thursday of this week, the day after tomorrow.
okay. How long can she stay there?
6 months, I believe, is the term, Your Honor.
Okay, so this isn't a 30-day, 28-day
No, and I think that I have that
detox / what's it?
summarized in my petition, in the petition. Well, I guess I don't have the timeline. My belief and understanding is that it's typically a 6 month regimen, an inpatient regimen where the women are housed at the house. They meet daily in group meetings. They meet individually with therapists and or counselors, and they have support through the house in that manner.
And so do they do regular testing?
I believe the answer to that is yes, Your Honor.
Because probation can't do that. You know that, right? I mean, everybody has this whole list of magical things that probation, half of them, probation, not you, but a lot of probation can't do in normal times, like monitor somebody's internet use. But
Yes.
nobody's going in to watch a pee in the cup these days. But if they're doing screens there, that changes it a bit, arguably.
I believe the answer to that is yes, and I can try to confirm that promptly as I can. Your Honor.
Okay. Where was and is it your opinion, where was she between 2017 and 2020? Because you say she was on probation and she's good. How much was she locked up at all during that time?
My belief and understanding is that once she was discharged from probation in 2018, until the date of this offense, she was in Massachusetts. She does have some support in the community, and specifically, there is a specific individual who I believe lives in, I think, Danvers off the top of my head, and I apologize, it's escaping me a little bit, but I think there's a woman who lives in Danvers who is a friend, who is actually a former social worker, who's retired social worker, who has supported Ms. Thames, and Ms. Thames did live with that person during that time period, including, I believe the most recent information I have is that Ms. Thames technically is still on the lease actually at that particular residence.
And she's not one of the people who had a restraining order, right?
That's correct. She's absolutely not one of those people. The last name of the person is Pellegrini, for if just so that not.
Okay. Because it seemed to me there was a restraining order in 2018. Hold on, with a woman's name, but hold on. So we've got Eric Rivers. I don't care. I don't know, but there were at least Kayla Sutton and Eric Rivers was the one in 2018, I think. Okay. All right. I've asked you a lot of questions and you still got some time. Is there anything you want to say that I didn't give you a chance to say?
I just, on behalf of Ms. Thames, would just reiterate that there are conditions of release that would ensure the safety of the alleged victim in this particular matter, including the stay away order with a GPS condition with an exclusion zone around that person's house if necessary. Alternatively, an order that Ms. Thames enter and complete any treatment as necessary at the women's shed at the Glennis Sheehan house, with an order that she stay and remain there, and that she sign all releases for probation so that they could monitor compliance. Those are conditions that, from Ms. Thames' perspective, would absolutely, at least in the short term, or at least for the pendency of the matter, reasonably assure the safety of the community, and as well as the particular named victim in this particular alleged victim in this particular matter. Your Honor.
Okay. Do you have a chance to say everything you wanted to say?
It's always a difficult question, Your Honor, but I'm going to say yes.
No, I know, and that's not a hint that you left something out. It's just the way I try not to assume it shut people out. So
I appreciate it very much, Your Honor, but I believe so. Thank you.
okay, thanks very much. Ms. Semmel, you're up.
Good afternoon, Your Honor. First of all, I just want to apologize for a mistake in my opposition when I suddenly decided that these events occurred in August instead of October. When I said August, I meant October. I hope that wasn't confusing at all.
I missed it. So you don't have to spend any time.
I clearly missed it until today when I was horrified. The basic argument of the Commonwealth, Your Honor, is that 3 different judges in this case have found this individual dangerous based on the circumstances of this case and her extensive criminal history. There was a 58A, which was allowed, the reconsideration motion was denied, and the bail petition was denied.
Since then we've got Nash, right?
Yes. So in the
and can I ask you something else? Was the woman injured I'm sorry, I'm going to let you finish eventually, I promise.
That's okay.
Was the woman injured at all?
We had inconsistent statements from the victim about her injury. There was a statement she made to a prosecutor, not to the police, that described more in the way of injury. It does not match, or she did not relate that to the police. I would expect, I hate to predict because I'm not the trial attorney, but I will note that the defendant has filed a motion to dismiss, which is being heard, I believe, on February 4th. With Mr. Cox can correct me if I'm wrong, in which he is okay, in which he has challenged the injury aspect of it, and also something to do with the breaking and entering. In speaking with the trial ADA, or the ADA who's most handled the case, I think she believes it is likely that the injury, that it will be partially null prost, and that the injury element of it will be taken out. So I think it would be fair for the court to not consider that as an offense that is with an injury, because I don't think that's the way it will come out.
So an assault and battery on a person over 60, but actually
Yes.
in this case 74, but not with an injury. Okay.
Right. I think what is troubling about this case is the defendant's very, very long history of similar crimes, of breaking and enterings, crimes which may not have been directed against a person usually, but certainly there's always that possibility, there's always that danger when you're breaking into someone's house, not to mention just the concern and the attack on the person's sense of privacy and security in their own home. And this was an escalation in the sense that the defendant seemed to not only pick out this person, but pick out this vulnerable person. This person's 74 years of age, who just walked into the house with her groceries and left the door open. And certainly scared this woman and restrained her, and those parts I think are consistent throughout her statements. And that's of significant concern. It may be that it would be best for the court to wait until after the February 4th hearing to rule on this, if that would be helpful, whatever is going to occur there. I believe, at that point.
What's it scheduled? Excuse me, I'm sorry, it's stupid asthma when I try to talk. What's it scheduled for besides a hearing on the motion to dismiss that part of that complaint? Because it didn't sound like there's a whole lot of mystery about that. I mean, I understand you're not the trial lawyer and somebody might have talked to the woman in the meantime and have a whole different thing, but
the last I knew that it was scheduled for a bench trial. I do understand that bench trials are not happening. I didn't realize it had been updated, the docket. What has typically happened on those dates is that if it is in fact scheduled for a bench trial, is that the Commonwealth needs to make a representation that they are in contact with the victim, that they could produce the victim if in fact they needed to. So that is another thing that might happen there. Our office has not had direct contact with the victim, I think, but has reached out to her through the advocate and summons and so forth, and is trying to make contact, but that has not been confirmed at this time. So that is the second thing that could happen.
do you have any information that that anything happened, that she did anything between 2018 and 2020? Like it looks like, to speak colloquially, like she was doing all right in that period of time and then arguably picked up or started to use again. I'm inferring, the nature of the crime.
I do not have any information to the contrary, Your Honor. I don't have any information of anything going on in that time period.
Okay. What's the danger if she goes to Lowell House? And if, assuming you've got I know there's a particular branch of it, but that's a term I've heard. But when she goes there, if she can stay there for a period of time, if they do testing, random testing, and she's on a GPS, so we know she's there, isn't that a better investment in long-term safety to get her sober if we can?
I think it, with the elements that the court has laid out, certainly, which I don't know if those, have been confirmed. Certainly our concern would be if she could leave the program before trial. And that would be of great concern to us because of the nature of her past defaults, because of her crimes, because of her really persistent drug use, which is an inference on my part based on her crimes, but I think it's a fair inference, and that we would certainly be concerned.
It's one that I draw as well, and I think, without speaking for Mr. Cox, so does he, and that's why he's scheduling. That's why he has the placement in mind.
Yes, so our concerns would be assuaged certainly if there were if there were a commitment to all those circumstances, and that she would not be able to leave after 30 days or so forth, and that there would be GPS and that she would in fact be getting treatment, because and I don't know what the security it is, in terms of people coming and going. Certainly it's for someone who hasn't followed the rules before. Certainly you can get caught on the GPS, but that doesn't necessarily stop bad things from happening.
All right, fair enough. I've had a lot of questions for you as well. Is there anything you want to say that you didn't get a chance to say?
No, Your Honor, that's all. Thank you.
All right. Well, thank you both. I don't think it will surprise you that I'm going to take it under advisement.
Your Honor, may I clarify? I apologize. I was just going to ask, because it came up in both of the statements. Could I just clarify one item about the statement I made about the document reflection?
My colleagues are very sensitive about rebuttal, but I'm perfectly willing to hear what you have to say.
I apologize. And this is really not so much rebuttal, just a clarification, because I didn't want my statement to be taken out of context. When I said that I believe the docket doesn't reflect bench trial anymore, I filed the motion, basically embedded in a motion, and also a motion for discovery that I expect is going to be heard on Thursday. But my statement was based on the mass course entry, which is a mass course entry from January 21st that indicates the bench trial date is canceled for the following reason per order of the court as of January 21st. And I haven't seen an official copy of the docket. I just wanted to clarify that so it wasn't
All
misconstrued.
right. Thank you, and I appreciate you being scrupulous about that, but I don't think anybody thinks you're misrepresenting, so, all right. Thank you both very much. Take